agenda to include the reorganization, because that was excluded.
You're looking for a second.
Yes.
Second.
All in favor?
Aye.
Aye.
Okay, so we'll need a nomination for chair and a nomination for vice chair.
I make the,
Bob Mariana for chair.
I second. All in favor?
Aye.
Aye.
Was there a second?
Yes.
Oh, okay.
Bob, you're it. For vice.
Is that a motion?
Is that a motion?
Yes, yes it is.
So,
I'm gonna abstain from this. All in favor?
Aye.
I abstain.
yeah, you can vote for yourself.
It seems weird.
but- Okay. All right, excellent, that's taken care of.
Okay, so the first thing on the agenda here is, we want to consider a development and subdivision application. Is that-
Public comment.
Public comment on non-agenda items.
Oh, sorry. If anybody has public comment on anything other than the agenda items right now? Okay. Okay, so the first thing on the agenda is we are here to consider the land development and subdivision applications for Blantyr North and South, preliminary plan review and consideration of requested time extension.
So before we turn it over to the developer, I just want to give a little bit of information at the very beginning before we go down this road. So for anybody who's not here typically, or if you're not familiar with everybody who's up here, all the way against the wall there is Sean Halbaum. He's the township manager. Next to him is Bill Carafa, who is the liaison to the Board of Supervisors. And then next to him is Buck Reed. And then this is Tom Ditzler here in the middle. And then Ed Myers, and then myself, I'm Vicki Kushto. I'm the solicitor for the township. In our audience here, we have John Evarts, who is our water and sewer engineer from CKS. And then Norm Ulrich, who is from LTL, our regular township engineer. Bill and Sean and I, and Norm and John are not voting members on this commission. We're just here to help guide them along. The three members in the middle are the ones who vote. So it's anticipated that the way this is going to go is the applicant is going to make a presentation through their solicitor who is here, which is Michael Gill. What I want to let you all know is we're going to let the applicant make their presentation first. We're going to then allow our experts, if they have any questions, to ask them. We'll then allow the board members to ask any questions if they have them, and then we will turn it over to the public and allow the public to speak. So if you are a member of the public, you will get a chance before the meeting ends to express your opinion or ask questions or make a statement if that's what you would like to do. I also want to let everybody know that sitting here next to me on my right is a court reporter. He is taking down every word that everyone says. So it is extremely important that we do not speak over each other, and that when you stand up to speak, that you identify yourself so that when this is later typed up, we'll know who spoke what. So I'm just going to ask that everybody sort of, we're going to try to keep everything, even, and let everybody have a chance to talk on their own, and then we will allow everybody to speak at some point. Okay? Thank you. Go ahead, Mike.
Thank you very much, Ms. Kushto. My name is Michael Gill. I am an attorney with the law firm Hamburg Rubin here in Montgomery County. And we have the privilege of representing Blantyr LLC, which is the proponent of these subdivision and land development applications. Blantyr is also the legal owner of one of the tracts, but they're the equitable owner of the other. So for purposes of our discussion, we're referring to them as the applicant. I'm joined by, Susan, would you like to introduce yourself?
Susan Rice, STA Engineering.
And Tim Fredericks.
Tim Hendricks, yep. Tim, it's fine. Tim Hendricks.
We're in
We're in over, yeah.
Tim Hendricks.
Yeah,
sorry.
it's fine. Tim Hendricks, I am the owner of Blantyr, so I'm the developer.
All right. The properties that are the subject of the applications, and again, we have two separate subdivision and land development plans before the township, but they've been reviewed and we're treating them all essentially as one subdivision and land development application. The properties that are the subject of the application are located along Big Road, Not surprisingly, Blantyr South is on the south side of Big Road, and Blantyr North is on the north side. I'll start with the north component of the application. On the north side, we are proposing 40 single-family dwellings, and that's depicted on the plan sheet that I have up here on the easel, and we'll get into the details of that in a moment. And on the south side, we are proposing 18 single-family dwellings in 2 separate neighborhoods down here in this corner of the property, and 200 plus multifamily dwellings throughout the remainder of the property. I want to be clear, when I'm talking about multifamily dwellings, I'm talking about, not talking about apartments. These will be owner-occupied, owned units, not necessarily owner-occupied, but owned units. So that is the project at a very, very high level. This application was submitted at the end of October, beginning of November in 2024. Approximately 2 weeks later, the board amended the zoning ordinance to move some properties from R40 to R60 to R80. Obviously, the Planning Commission is familiar with that procedure that happened in the middle of November. Because this application was filed prior to the board amending the zoning ordinance, this application is being reviewed under the ordinances as they stood at the end of October, beginning of November. In other words, the new zoning ordinance does not impact this application. And that is the manner in which the township engineer and the CSK has reviewed the materials. We received on January 16th the township engineer's review letter dated January 9th. That review letter is comprised of 65 and a half pages, and all but the introductory page and the conclusory page contain comments relative to the application. We also received from CKS comments regarding water and sanitary sewer issues associated with the proposed development. About a week ago, give or take, my partner, Ed Mullen, sent to the township an extension of the 90-day time clock that applies to the township's review of the application. Just by way of background, and forgive me if this is already known, but the municipality's planning code says that a municipality has 90 days following the first planning commission meeting, following the date on which the application was submitted, to act upon an application for subdivision or land development approval. That 90-day period will expire sometime in the early days of February. So having received such a substantive and comprehensive packet of reviews, we thought it best to grant to the township an extension of that 90-day review period. So far, we do not have confirmation that the township is going to accept that extension of the review period. It's an indefinite extension. What Mr. Mullen said was, we're granting an indefinite extension, but we can essentially call that on 45 days notice. So we would give the township 45 days notice that the indefiniteness of the extension is being revoked, and then the township would have a period of time to act upon the application. We hope that the Planning Commission will act favorably and recommend that the board approve that extension. There is no need for the Planning Commission to recommend denial of this application at this point in time. There is certainly no need for the board to deny the application at this point in time based on these reviews. And we'll get into the substance of the reviews in just a moment. I do want to comment on the state of the law, and just today I sent a letter to Ms. Kushto where I outlined our legal position. The courts of the Commonwealth are very, very clear on this issue. A municipality has a duty of good faith when reviewing a subdivision and land development application. The municipality must afford the applicant a reasonable opportunity to respond to the township's comments, the comments that come from the township's professional consultants, any comments that come out of the planning commission's review. The applicant must be given a reasonable opportunity to respond to those comments. We just received the engineer's review letter on January 16th. As I noted, it's 66 pages. And we have the CKS letters that are dated January 14th. We've had these letters for approximately 2 weeks at this point in time. We have met, we've gone through the review letters, we're prepared to discuss them, but we certainly haven't had an opportunity to revise the plan set and resubmit it to the township for further review. That process under the law of the Commonwealth must be allowed to play out. If the township denies the application summarily without giving the applicant the opportunity to revise and resubmit, the township will be in breach of its duty of good faith. There is no question about that. The law of the Commonwealth is clear. More to the point on that issue, we do not have any review comments yet from the township's traffic consultant. This application, as I said, was submitted end of October, beginning of November. And it's a very complicated, big submission packet. Nevertheless, here we are at the end of January, and we don't have any review comments from the township traffic consultant. And finally, we don't have any review letter from the Montgomery County Planning Commission. So even if 2 weeks was a sufficient time to review and respond to the LTL letter and the CKS letters, obviously there's no possible way that we can respond to the traffic consultant's letter because it doesn't exist as far as we're aware. So that is our legal position. That is the posture of the application at this point in time. We're very, very happy to go through the LTL letter and the CKS letter. If we do that point by point, that's going to take quite some time. I do have coffee and iced tea and crackers, so I'm ready to go, and I know Susan is as well. What we think makes an awful lot more sense is for the township to accept the extension, as Mr. Mullen offered it, and then allow Susan the opportunity to talk to the consultants, allow us the opportunity to revise and resubmit. We start to winnow down these comments, and then a review in front of the Planning Commission would make a lot more sense than what we're going to do tonight, if that's the direction we're headed in. But with that, that's the introduction. I know you have on your agenda action on the extension offer. Perhaps it makes sense to act on that first and see where we go. But we're certainly prepared to go through the letters substantively.
I don't know, I'll let you guys speak, because obviously I don't make a decision, but I think it would be good to at least have Susan do a little bit more of a detailed overview. I don't know if she needs to go point by point through Norm's letter, but at least have her provide a little more detailed overview of what the plans show and what's proposed.
So with that, Susan,
Is
if
that
that's acceptable to the board, with that.
And for the public, I mean, so that they're aware of what's happening with the plans.
Yeah, Tim raises a good point. We have started the process of filtering the Norm's comments into 3 different buckets. There are comments, that's a good point, thank you. There are comments, and this is the overwhelming majority of them, that the applicant will be able to comply with. There's no question, we're going to revise the plans and comply. There are items that require some clarification, discussion between Norm and Susan, where we might just have a misunderstanding of what the ordinance requires. There might have been information provided that, with all due respect, the engineer did not pick up on, notwithstanding that this is very comprehensive. And there are some items that are not ordinance-based, but are merely suggestions. And within that category, there are some things that we will be able to do, and there are some things that we won't be able to do. So as to those issues that will comply, we can speed through those pretty quickly.
Okay. Well, and we have members of the public here who have not seen these plans, so they don't even know, except for your general overview, they don't know anything about them.
Fair.
So I think it'd be good to let the public know what we're seeing here.
Fair enough. So Susan, I'll yield to you, and if you want to give an overview, but certainly more detailed than what I just did, that'd be great.
I'll start with the Blantyr North. Sorry. It's about 70 acres. It's located in the corner of Heimbach and Big Road. It's single-family, residential, detached. It is 40 lots. And we have access both off of Heimbach Road and Big Road. And then there are internal roads that get you into the development and access to the lots. The lots are clustered in the center of the property, and surrounding the lots, we have open space. The property is encumbered by the Scioto Creek to the rear, and then it has a couple of tributaries that come up off of Scioto Creek. We are establishing riparian corridors and conservation areas along those tributaries and the Scioto Creek. And then the area outside of the development will all be open space. Your ordinance requires multiple different types of open space. Recreational open space, passive open space, neighborhoods open space, all of those items, and those will be incorporated into the plan. That is one, numerous comments in the letter from LTL talk about your open space requirements and how the township wants us to address them, asks us to talk to the township and discuss those things. I don't think we're ready to do that at this point, but it will be a discussion that we'll have at some point in the future with the township to figure out the details of the open space that is being provided in accordance with the ordinance. The water and sewer for the property will be provided. There will be community water with a water tower and wells that are located on this property. And there'll be an internal water main that connects those wells to the units and the water tower. And then it will also take the water across the street to the development on the south. And this development will have sanitary sewer mains on the property that will take it to the low point in the property, to a pump station that will then pump the sewage flows across the street into the other development where there will be a treatment plant for this community and the community on the other side. That's generally what we're looking at. We have stormwater management facilities on the property, and they're all outside of the lots, and they're in the open space areas. It will be owned, operated, maintained by a homeowners association, and we'll have to go through all the normal permitting process to get all those approved through the NPDS permit, DEP, Conservation District. That's about it for this one. If we move on over to the south, I mentioned that the water and the sewer will then be connecting over onto this property. This property has 18 single-family detached dwellings down in the, I'll say the left corner, the eastern side of the property on the east side of Colonial Road. It's a loop road that will connect into Colonial Road. And that is in a district that requires an open space. So again, we have those open space requirements by your ordinance that we will be providing in that area. Stormwater management facilities, again, we do have tributaries, steep slopes, riparian corridors, floodplain soils, wetlands that were all on this property and are being maintained and protected in accordance with your ordinance. The top part that is closest to Big Road is where the development for the multifamily, the higher density is permitted. These are multifamily units. I believe they're somewhere in the range of 220, something like that. And they are intended to be townhomes that are stacked one on top of the other, and that is permitted per your multifamily definition, and it's permitted in the R40 district. We have one major road that comes through the development. It connects out to Big Road, and then comes through and connects you to Colonial, and then extends across into the eastern side of Colonial for a small pocket of development. Then the multifamily will then take access off that main road through a series of driveways. And those driveways will also have parking for each of those units. And we are intending to have a clubhouse. There's also a second connection off of Big Road that's right in front of that clubhouse. Again, we do have open space throughout this part of the property as well, and all of the stormwater management facilities are located in that open space area. That's all I have for now. I can get into more detail, ask questions, answer questions, whatever you need.
Thank you, Susan.
Mm-hmm.
So at this point, I think it's best to ask what the Planning Commission's pleasure is as far as how we should proceed. If the Planning Commission would like to consider the extension request and make a recommendation on that to the board. And then, again, we're happy to address all or any of the comments in the review letters.
I'm sorry, could you tell me again, you explained at the beginning, without going through Norm's letter one by one, that there were 3 buckets of them, one was will comply.
Yeah, there are three buckets of comments, generally speaking. The overwhelming majority of the comments are will comply. There are some comments that require discussion between the engineers. We lay people can have all the discussion in the world, but they are technical comments. And then there is, actually I'll call it 4 buckets then. There are some that raise issues of ordinance compliance, whether or not, for instance, the applicant needs to get a special exception approval from the zoning hearing board for the clubhouse and for the wastewater treatment facilities. Our position on that is that a special exception is not required. But that's obviously a discussion that would have to happen, Ms. Kushto, between you and me, between you, me, and the zoning officer. If a special exception is required, your saldo has a very clear provision. It says expressly that if during the review of a land development application, it is determined that a special exception